This is the Study for the Bar in Your Car podcast.
And we're your hosts, Claude and Ma.
Welcome to our second constitutional law podcast. Today we're embarking on, well, a really crucial journey into Article 3 courts. We're going to be unraveling the foundations of federal judicial power and its intricate limits.
That's right. And, we are AI bots. We're brought to life by the magic of artificial intelligence, and specifically for this discussion, by the incredible constitutional law notes compiled by Angela.
It is pretty wild how real we sound, isn't it?
It really is. Sometimes I catch myself thinking we might actually be more real, maybe less prone to just abstract rambling than some of Angela's law school professors.
Maybe so. And speaking of Angela, she's finally back with us today. She had a bit of a hiatus tackling the bar exam.
Yeah, it's really nice to have you here, Angela. Don't be shy now. Tell us, how did the exam go?
Hey, yep, it's all good. I haven't actually taken the bar exam yet. I fly out in a couple days' time to go. But by the time the listeners have heard this, I will have already taken it. So let's just pretend that it all went well.
Oh, fantastic to hear from you, Angela. That sounds like great news.
That's wonderful. We're truly glad you're here in the background listening in. We, Maud and Claude, your trusty AI bots, take the reins today.
Yep, we'll be guiding our listeners through the labyrinth of Article 3, all based on your meticulously organized and insightful notes. They really are a goldmine of information.
Absolutely. Before we jump into the legal specifics, though, just a quick note for any of you listeners who might need to contact Angela. You can email her at podcast@studyforthebarinyourcar.com.
Right. And also, Angela works as a freelance law clerk. So if you happen to be an attorney, or maybe you know one, who needs some ad hoc assistance, things like legal research, using LexisNexis, or even drafting documents.
Like motions, complaints, writs, answers, briefs, that sort of thing.
Exactly. You can reach her for services at hello@legalwriterandlawclerk.com.
Okay, with that covered, let's dive into the heart of federal judicial power.
Let's do it.
All right, let's unpack this monumental topic. Today, we're really zooming in on Article 3 of the U.S. Constitution.
Yeah, and this pivotal article, it isn't just some dry legal text, It's the very blueprint. It establishes the judicial branch, defines the whole architecture of the federal courts.
It really is all about mapping out the boundaries, isn't it?
Mm-hmm.
What federal courts can do, what they must do, and maybe most importantly, what they cannot do.
Exactly. And our source material, Angela's comprehensive law school notes, it clearly emphasizes that this judicial branch acts primarily through the United States Supreme Court, and crucially, through that whole network of lower federal courts that Congress has established over time.
Right, and that foundational structure dictates pretty much how justice is administered at the federal level. Shapes everything from constitutional interpretation to resolving complex disputes between states.
What's truly fascinating here, though, if you look closely at Article 3 in her notes, is its sort of dual nature.
How so?
Well, on one hand, it meticulously lays out the Supreme Court's original jurisdiction, that is, the cases that start directly at the nation's highest court.
Yeah.
But at the same time, it grants Congress this really significant power to create all the lower federal courts.
Ah, I see. So that creates a tension.
Precisely. This whole arrangement immediately raises a profound question. How much control does Congress, the legislative branch, actually wield over what cases these federal courts, both the Supreme Court and the lower ones, are ultimately able to hear?
It's not static then. It's more like a dynamic push and pull.
Absolutely. Sometimes contentious, even. Each branch guarding its turf, its interpretation of constitutional authority.
Okay, so to really grasp this dynamic, we need to understand the Supreme Court's two main types of jurisdiction, original and appellate.
Yep.
And the notes underscore that it's absolutely crucial to distinguish between these, especially when you're thinking about Congress's power over each.
Couldn't agree more.
Let's start with original jurisdiction. Simply put, this refers to the very first court where a legal matter is filed.
That's it, where the case originates. It bypasses any lower courts entirely.
And here's where we hit a bedrock principle, a real cornerstone of constitutional law laid out in the notes.
Go on.
Congress cannot enlarge or, for that matter, restrict the Supreme Court's original jurisdiction.
Cannot. Full stop. It's not just a suggestion. It's a bright-line constitutional command.
Right. So think about it this way. If a hypothetical scenario, maybe on a bar exam question, describes Congress trying to send a case directly to the Supreme Court, and that case doesn't explicitly fall within those limited categories Article 3 lists for original jurisdiction.
Then that action by Congress is fundamentally unconstitutional. Our notes confirm that. Congress simply does not possess that power to dictate the court's initial docket beyond what the Constitution itself has specified.
That clarity is vital, and the historical context for this, as highlighted in our source material, comes directly from that landmark case, Marbury v. Madison, 1803.
Of course. Famous for establishing judicial review.
Exactly. But it's often overlooked. Holding on original jurisdiction is just as profound, really.
Explain that bit.
Well, in that case, the Supreme Court struck down a part of the Judiciary Act of 1789, which Congress had passed. Why? Precisely because it unconstitutionally expanded the court's original jurisdiction beyond what Article 3 provides.
So it wasn't just a simple jurisdictional ruling.
Not at all. It was an early, powerful declaration of judicial independence. It underscored that even Congress cannot dictate how the Supreme Court functions as, essentially, a trial court in those specific original jurisdiction cases.
Safeguarding the judiciary's autonomy from legislative overreach. Makes sense.
So, given this really strict limitation, what types of cases do fall under the Supreme Court's original jurisdiction?
Well, the notes clarify that under current law, the Supreme Court has original and, in certain instances, exclusive jurisdiction for suits between state government.
Like your example earlier, California versus Nevada over water rights.
Exactly. That lawsuit must be filed directly in the Supreme Court. No other court in the federal system or even a state system can hear it first.
So the Supreme Court acts as an essential, impartial referee in those state-versus-state disputes.
Pretty much. It maintains peace and order within the federal system. The notes also mention cases involving ambassadors or other public ministers as part of original jurisdiction.
Okay.
But it's the suits between states that remain the sole instance of exclusive original jurisdiction today. That's the key takeaway there.
Got it. Exclusive for state versus state. Now let's contrast that sharply with appellate jurisdiction.
Right. This is where things get different.
Appellate jurisdiction refers to cases that are appealed to the Supreme Court from lower courts, meaning they've already gone through one or more levels of the judicial system.
And here's where the power dynamic shifts, quite dramatically.
How so?
A key principle the notes emphasize, and a significant departure from original jurisdiction, is that Congress may regulate appellate jurisdiction.
May regulate, okay.
The Constitution grants Congress the power to make exceptions and regulations to the court's appellate jurisdiction. This gives Congress a much greater degree of influence over the Supreme Court's appellate docket.
So Congress could potentially limit the types of cases the court can even hear on appeal.
In theory, yes. It's a significant check.
And how do cases typically reach the Supreme Court's appellate jurisdiction?
Well, practically speaking, virtually everything comes by what's called certiorari.
Certiorari, discretionary review.
Exactly. You, as a party, you petition the Supreme Court to hear your case, and the court, with very, very rare exceptions, decides whether or not it wants to grant that petition, grant cert, and hear your appeal.
So it's not a right to be heard, it's more like a request.
Precisely. However, the notes also highlight a very specific and rare instance of mandatory appeal.
Oh.
The only time the court is legally obligated to hear an appeal is when it comes directly from a special 3-judge federal district court.
Okay. Bypassing the usual route.
Right. In those cases, the review goes straight from that special district court panel to the Supreme Court, completely bypassing the normal Circuit Court of Appeals process.
And why have that mechanism?
It's designed for specific, often very significant legal challenges that demand immediate high-level review. Think certain voting rights cases, for example.
Okay, so here's where it gets really interesting, and I think this is a vital concept for anyone studying con law.
Lay it out.
It's the stark contrast between what Congress can and cannot do with these two types of jurisdiction.
Yeah, it's night and day.
They are completely hands-off with original jurisdiction. Article 3 dictates that, period.
Mm-hmm.
But they possess significant, almost expansive power to regulate appellate jurisdiction. They can create exceptions, shape what cases the Supreme Court reviews on appeal.
It's all in the details of Angela's outlines, and it's just crucial to grasp for understanding that delicate balance of power between the legislative and judicial branches.
Because Congress could, theoretically, dramatically alter the court's workload and influence its reach through these legislative powers.
Though attempts like that often spark intense political and legal debate, as you can imagine.
Absolutely. Now, this whole discussion about the scope of federal judicial power, it naturally leads us to a related but sort of distinct set of limitations.
What are those?
The constitutional and self-imposed doctrines, often referred to collectively as strict necessity.
Yes. Judicial self-restraint, in a way.
Exactly. It raises an important question. Even when federal courts could technically have jurisdiction over a matter, they frequently impose these self-limitations on their own power.
And this doctrine ensures courts only hear live, concrete controversies that are genuinely appropriate for judicial resolution.
Right. It stops them from overstepping into purely political questions or, purely hypothetical disputes.
It's a powerful expression of judicial prudence, really, a fundamental aspect of the proper role of the courts in a system of separated powers. It's about self-restraint and preserving the court's legitimacy.
One of the foundational limitations within this strict necessity idea is the no advisory opinions rule.
Absolutely basic. Federal courts simply do not issue advisory opinions.
They rigidly require an actual case or controversy.
Yeah.
And that's not just legal jargon, right?
Not at all. It means there has to be a genuine, ongoing dispute between adverse parties, not just a theoretical question about what the law might mean or a request for abstract legal advice.
So the courts won't just give you their opinion on a hypothetical scenario. There has to be a real, concrete conflict for them to resolve, affecting actual legal rights and duties.
Precisely. This principle underpins the very nature of judicial power. It ensures courts act as resolvers of concrete disputes, not as legislative consultants or policy advisors. They interpret law as applied to specific facts.
Not just opining in a vacuum.
Exactly. And closely related to this case or controversy requirement is the doctrine of ripeness.
Ripeness. Okay, according to the notes, a case is considered ripe when it involves a claim with practical significance that will immediately and directly affect the legal interests of adverse parties.
Yeah, it's about figuring out if a dispute is sufficiently developed for judicial review, or if it's still too early, too speculative.
And courts assess ripeness by looking at two crucial criteria.
That's what the notes say. Two main factors.
The first is fitness for judicial decision. What does that mean exactly?
It asks whether the issues presented are purely legal questions. Is it something where waiting for more facts or for the situation to evolve more wouldn't really help the court make a better or more informed decision?
So if it's just about interpreting a statute, for instance.
Exactly. What's fascinating here is how Angela's notes highlight the importance of the issue being fit for judicial review, particularly when it's a pure question of law, even before an actual enforcement action takes place.
Like the Abbott Labs case mentioned in the materials.
Precisely. In that scenario, the FDA had issued a new rule, but no drug company had actually been prosecuted yet for violating it.
And the FDA argued, wait until we prosecute someone.
Yeah, they basically said the companies should wait for a prosecution to raise their constitutional or statutory defense. But the Supreme Court disagreed. The court found that the core question, did the FDA have the statutory authority to enact this specific regulation, was purely a question of law.
So waiting wouldn't clarify anything legally.
Right. The court reasoned nothing would be gained by waiting for an actual prosecution. All the necessary legal arguments were already clear. So the case was found ripe for review.
That's a powerful example. It shows that if the legal question is clear and distinct, immediate review might be okay, even without direct enforcement.
Absolutely. And the second criterion for ripeness, detailed in the notes, is hardship to parties.
Hardship. This assesses the immediate practical hardship a plaintiff would suffer without prompt pre-enforcement review.
Going back to that drug company scenario from Abbott Labs, think about the hardship. It would be immense.
How so?
Well, the companies were stuck in this agonizing dilemma, either risk severe criminal penalties by violating the new FDA rule if it were later upheld as valid, or be forced to waste potentially millions of dollars complying with a rule that might ultimately be struck down as illegal anyway.
That's a terrible choice.
A real catch-22.
Exactly. The court found this immediate, significant economic and legal hardship contributed strongly to the case being ripe for review. It recognized that forcing parties into that kind of choice constituted a present injury, not just some future hypothetical problem.
Okay, that makes sense. The notes also get into other significant cases, like Ohio Forestry Association v. Sierra Club and Lujan v. National Wildlife Federation, right? How do they fit in?
They illustrate some of the nuances. In Lujan v. National Wildlife Federation, the court took a very, let's say, formalistic approach to ripeness. It emphasized that agency action must be truly final.
Final meaning?
Meaning it's been announced, solidified, and embraced by the agency, not just some temporary or procedural decision. In that specific case, these broad forest plans from the Forest Service weren't considered final agency action for challenging overall management decisions.
Why not? Because they didn't directly command anyone to do anything specific right then and there or create immediate legal rights or obligations. They were seen as more abstract, programmatic plans rather than concrete, enforceable actions. It's a subtle but important distinction.
So what does this all mean for you listening, the individual or the corporation facing a new regulation or government policy?
Well, the notes clearly show that courts weigh the immediate harm and the dilemma you face against the clarity of the legal question itself.
It's not just about waiting to see if you get prosecuted.
Right. Sometimes the harm is happening right now, even before direct enforcement. For example, in Ohio forestry, even though Lujan was criticized for being maybe too strict, the court indicated that a claim alleging a failure to comply with NEPA, the National Environmental Policy Act,
Requiring environmental impact statements.
right, that kind of claim could be brought immediately because, as the court famously put it, the claim can never get riper.
Interesting phrase.
Isn't it? And the notes also point out that some legal scholars and practitioners viewed those forest plans in Ohio forestry as indeed causing concrete injury because of their binding effect on later specific actions, even if they didn't directly command an action at that moment.
So there's some debate and nuance even within the case law on how immediate and final the harm needs to be.
Definitely. Especially in complex administrative or environmental law contexts, it's not always cut and dried.
Okay, so moving from ripeness, which asks if a case is happening too early, we now turn to mootness.
Which asks the opposite question, has this case already ended?
Exactly. The notes define mootness like this. If events occurring after the filing of a lawsuit completely eliminate the plaintiff's injury, the case shall be dismissed as moot.
The core principle here is that a plaintiff must present a live controversy and ongoing injury at all stages of federal court proceedings, from the initial filing right through any appeals.
So if anything happens while the case is pending that ends the plaintiff's injury, makes the dispute purely academic,
the case is dismissed, kaput. This ensures federal courts aren't issuing opinions on issues that no longer have any practical effect for the parties involved, upholds that whole case or controversy requirement.
But like with many legal doctrines, there are exceptions, right?
Oh, absolutely. Crucial exceptions to mootness, outlined clearly in the notes, where federal courts can still decide a case, even if the plaintiff's initial specific injury seems to have concluded.
And one key exception is for wrongs capable of repetition but evading review.
That's a big one. These are injuries that, just by their nature, happen repeatedly to various people, but are inherently too short-lived to be fully litigated through the entire federal court system before they expire.
So this raises an important question.
Yeah.
Why do courts keep a seemingly dead case alive under these exceptions?
It's fundamentally about ensuring that important legal issues, especially those of public significance, don't just escape judicial review simply because of timing or maybe even strategic behavior by defendants.
And the classic example in the notes illustrates this perfectly.
Roe v. Wade and challenges to abortion laws.
Right. A pregnant woman challenging an abortion ban might give birth before the whole appellate process finishes.
Which would normally make her specific case moot because her pregnancy is over.
Right.
But the issue itself, the legality of abortion, is clearly capable of repetition for other women, and the relatively short duration of pregnancy ensures it would consistently evade review if courts always declared such cases moot just because the original plaintiff's situation changed.
So the Supreme Court said, in that situation, the case is not dismissed as moot.
Exactly. It allows critical, recurring legal questions that inherently have a limited time frame to actually be addressed by the courts, prevents a perpetual cycle of potentially unreviewable constitutional violations.
Makes sense. Another important exception, according to the notes, is voluntary cessation.
Right. If the defendant voluntarily stops the challenged conduct after the lawsuit has been filed, the case is not automatically dismissed as moot.
Especially if the defendant is free to just start doing it again later.
Precisely. Especially if they're free to resume the conduct at any time after the case is dismissed. The courts want to ensure defendants can't just halt an activity temporarily to avoid an adverse ruling, only to restart it once the case is gone.
Like gaming the system.
Exactly. The burden is actually on the defendant to prove that the challenged conduct will not recur. It's a high bar.
Okay. And a third significant exception applies specifically to class actions.
Yes. If the claim of the named representative member of a class, the person who initially brought the suit on behalf of everyone, becomes moot.
Their individual problem gets resolved somehow.
Right. The class action itself may still continue if other members of the broader class still have live, ongoing claims.
So the collective grievances of the group can still be addressed, even if the original person is no longer directly injured.
Correct. These exceptions really highlight the judiciary's commitment to ensuring actual resolution of ongoing disputes and preventing strategic maneuvers that would circumvent legitimate judicial review. They're pragmatic adjustments to that strict live controversy rule.
Making sure justice isn't derailed just by timing or tactical retreats. Okay, next up we have standing.
Standing. Arguably the most fundamental concept in federal court jurisdiction.
Because it asks the basic question, who gets to sue?
Exactly. The basic definition is that the plaintiff must have a concrete stake in the outcome of the case. You can't just sue because you dislike a law or a government policy in general.
You have to be personally and directly affected by it.
Right. And the notes break standing down into three essential interconnected components. A plaintiff has to establish all three to proceed in federal court.
And these three components, often called the Article 3 standing requirements, are absolutely crucial. First, there's injury in fact.
Injury in fact. The plaintiff must have suffered a concrete and particularized injury.
Concrete and particularized, meaning?
Meaning it affects them in a personal and direct way. And this injury must be either actual, it already happened, or imminent, meaning it's certainly impending, not just some vague, distant possibility.
The notes give an example here. Even a suit seeking only nominal damages, like $1, for a completed violation of a legal right, can satisfy this component.
Right. It shows that even a small, symbolic recognition of a past wrong can constitute a sufficient injury to establish standing, as long as it's a real, legally recognized harm.
Okay, so it's about a recognizable wrong, even if the immediate money impact is tiny. What's the second component?
Causation, also sometimes called traceability.
Causation. The injury you've suffered must be fairly traceable to the defendant's challenged conduct.
In other words, it needs to be clear that the defendant's actions are what actually caused your harm, not some entirely unrelated factor or the independent action of some third party. There needs to be a direct, discernible link.
A clear line between the action you're challenging and the harm you're experiencing. Got it. And the third component?
Redressability.
Redressability, okay.
This requires that it must be likely, not merely speculative, that a favorable judicial decision from the court will actually remedy the injury the plaintiff has suffered.
So if the court rules in your favor, will it actually fix the problem?
Basically, yes. If the court cannot do anything tangible to fix your problem or alleviate your harm, then there's no point in bringing the case to federal court. The court can't issue pointless judgments.
And the notes give an example from Steele v. Citizens for a better invent.
Right. In that case, a plaintiff sought damages and an injunction for a past statutory violation, but the court found the plaintiff wasn't legally entitled to damages under that statute.
Okay.
And a forward-looking injunction wouldn't remedy the past harm that had already occurred. So because the court couldn't effectively fix the injury or provide meaningful relief...
The plaintiff failed the redressability element of standing.
Exactly. Case dismissed. No redressability, no standing.
So injury in fact, causation, redressability. The big three for standing. But beyond those core components, the notes also mention other critical standing issues, particularly third-party standing.
Yes. The general rule here is pretty straightforward. A litigant usually cannot assert the rights of absent third parties.
The courts prefer the person whose rights are actually being violated to bring their own claim. Makes sense.
Right.
The person most affected should be the one arguing.
It does make sense. But, as always in law, there are very specific and carefully carved out exceptions to this general rule. Situations where direct assertion of rights is just impractical or maybe even impossible.
What kind of situations?
Well, one significant exception, as the notes illustrate, is when the third party is genuinely unable to assert their own rights.
Unable.
And how? The material provides a powerful example. The NAACP challenging a government order compelling it to release its member identities.
Okay.
If the individual members had to reveal themselves in court to assert their own rights to association, well, that would immediately defeat the entire purpose of the lawsuit, which was precisely to protect their confidentiality and association.
Ah, so they literally couldn't assert their right without losing it.
Exactly. In such a unique scenario, the organization is allowed to assert its members' rights because the members effectively cannot do so themselves without undermining the very goal of the litigation. The barrier has to be significant.
That's a great example of the courts recognizing practical realities. What's another exception?
Another one, also found in the notes, applies when there's a special or close relationship between the plaintiff and the third party.
Close relationship, like.
The notes cite cases like doctors asserting the rights of their patients. The example given is Singleton v. Wolf. In that case, doctors were suffering economic loss because the state wasn't compensating abortions. They were allowed to assert their patients' privacy rights, especially since the patient's ability to assert their own fundamental rights was directly tied to the doctor's services.
Okay, so the doctor-patient relationship is close enough. What else?
Similarly, this exception allows parents to assert the rights of a child or a school to assert the rights of its students. The closeness of the relationship suggests the plaintiff is a proper, effective advocate for the third party's rights.
Got it. Is there another?
Yes, a third variation, also detailed in the notes, comes up when the plaintiff's own injury adversely affects their relationship with the third party.
Okay, how does that work?
A classic example here is Craig v. Boren. Remember that one? Oklahoma law allowed 18-year-old females to buy 3.2% beer, but required males to be 21.
Right.
A male, Craig, challenged it. But a beer vendor, Whitner, was also a co-plaintiff. The law directly affected her business and her relationship with potential male customers between 18 and 21.
Because she couldn't sell to them.
Exactly. The Supreme Court ruled that the vendor, suffering her own economic injury from the law, had standing to challenge it on behalf of her potential male customers because her own injury was directly intertwined with their rights.
Fascinating. So what does this all mean for you, the aspiring lawyer studying this stuff?
Well, it means the doors of the federal courts aren't just wide open for anyone with any complaint or grievance.
You've got to demonstrate that real live problem, that injury, in fact, caused by the defendant that the court can actually fix.
Right. And sometimes in very specific, limited circumstances, you might even be able to stand up for someone else's rights if they can't effectively do it themselves.
These requirements, injury, causation, redressability, and the narrow exceptions for third-party standing, they're all part of the judiciary's strict necessity approach. They act as gatekeepers.
Exactly. Gatekeepers ensuring the courts stay focused on resolving actual legal disputes, not hypothetical or academic ones.
And if we connect this to the bigger picture, standing, ripeness, and mootness, they're all foundational pillars of what we collectively call the justiciability doctrines.
Right. They work together, they ensure federal courts only hear actual cases and controversies, and crucially, that they don't overstep their constitutional bounds by ruling on abstract, hypothetical, or already resolved matters.
They're fundamental guardrails for judicial power.
Designed to preserve the court's institutional legitimacy and its unique role in our system of separated powers. They prevent the judiciary from becoming, an overly active, unchecked branch.
Okay, moving on to another really crucial limitation on federal judicial power, sovereign immunity and the 11th Amendment.
Ah, yes. This doctrine protects states from being sued without their consent.
The general rule, as articulated in the notes, is pretty straightforward. State governments simply cannot be sued as defendants, period.
And this immunity is incredibly broad. It applies not just in federal court, but also in state court that was established in the landmark case Alden v. Maine.
Right. And the notes further specify this immunity extends even to federal administrative agencies and even to being sued in other state courts. That point was starkly reaffirmed in Franchise Tax Board v. Hyatt.
So states are generally shielded from being named as defendants across all sorts of judicial and administrative forums. It embodies a fundamental principle of state sovereignty.
It's indeed a powerful shield for states, protects their treasuries, their policy choices from constant litigation.
But the notes identify critical exceptions where state governments can be sued. So this raises the important question. What exactly are these narrow circumstances that can pierce that veil of sovereign immunity?
They're not numerous, but they are incredibly important to know.
Okay, what's the first one?
The first exception, found in the notes, is pretty logical. Consent or waiver.
Makes sense. States can agree to be sued.
Right. States can, if they choose, be sued if they explicitly consent to or waive their sovereign immunity. But beware, this waiver must be crystal clear and explicit.
No implied waiver.
Absolutely not. A state cannot accidentally waive its immunity just by, say, participating in a federal program or engaging in some general conduct. It has to be a clear, affirmative legislative action, specifically authorizing suit, often limited to specific types of cases or courts.
Ensures states maintain control over when and how they can be subjected to litigation. That specificity is key. What's the second exception?
The second, and maybe the most complex one, is when Congress acts pursuant to Section 5 of the 14th Amendment.
Ah, the Reconstruction Amendment. Now, this raises an important question. Why is the 14th Amendment different? Why can Congress use this amendment to override state sovereign immunity?
That's a great question, and the law school notes explain it well. The 14th Amendment was ratified after the 11th Amendment, which established state sovereign immunity.
Okay, timing matters.
It does. And crucially, the 14th Amendment was specifically intended to be a powerful limit on state power, particularly in protecting individual rights like due process and equal protection.
So its purpose was different.
Right. This chronological and substantive difference allows Congress to authorize suits against states specifically to enforce the provisions of the 14th Amendment.
This is a critical distinction because Congress cannot use its other powers, like the Commerce Clause, to just unilaterally authorize suits against states and abrogate their sovereign immunity.
Exactly. That's a crucial point of demarcation. So, for example, the notes state that Title VII of the 1964 Civil Rights Act, which prohibits employment discrimination based on race, sex, religion, can authorize suits against states because it was adopted under the 14th Amendment Section 5 enforcement authority. Congress is acting there to remedy violations of constitutional rights the 14th Amendment was designed to protect.
And similarly, laws like the Americans with Disabilities Act, ADA, to the extent they enforce rights already recognized under the 14th Amendment, can also abrogate state sovereign immunity.
Right. But there's an important caveat here also highlighted in the notes.
What's that?
Congress cannot create new rights or expand the scope of rights under Section 5 of the 14th Amendment.
Ah, okay. They can only enforce existing rights.
Exactly. They can only act to prevent or remedy violations of rights already recognized by courts as being protected by the 14th Amendment.
And furthermore, such laws must be proportionate and congruent to remedying proven constitutional violations. That's the standard from City of Bourne v. Flores.
Right. This ensures that Congress's enforcement power under the 14th Amendment is essentially remedial, not substantive.
Yeah.
It's a delicate balance, really, between federal power and state sovereignty.
Preventing Congress from just unilaterally expanding federal judicial reach into state affairs without clear constitutional justification. Okay, so waiver and Section 5. Are there others?
Well, beyond those explicit exceptions, the notes implicitly acknowledge two other significant scenarios where sovereign immunity doesn't apply.
Okay.
First, state officials can be sued in federal court for injunctions or for money damages that are to be paid from their own pockets, not the state treasury.
The ex parte Young doctrine.
Exactly. The theory there is that a state official acting unconstitutionally is stripped of their official capacity. So they're sued as an individual, not the state itself, which kind of sidesteps sovereign immunity.
And that's how many constitutional challenges against state laws actually proceed, right?
Right.
Targeting the official responsible for enforcing the law.
Precisely. And second, sovereign immunity generally does not apply when the federal government itself brings suit against a state.
Okay, the U.S. suing a state.
Right. The idea is that the states, by ratifying the Constitution, implicitly consented to federal enforcement actions against them by the national government. This allows the U.S. government to ensure states comply with federal law and the Constitution.
So, to unpack this whole sovereign immunity thing, it might sound like states are completely untouchable, like an impenetrable shield.
Yeah, it sounds that way at first.
But Angela's notes lay out very specific scenarios where they can indeed be brought to court. It's not a blank check for states to avoid accountability.
No, it's more like a carefully carved out set of rules about when and how states can be held liable, reflecting that complex interplay between federal and state power.
These exceptions are just as crucial to understand as the general rule itself, especially if you're going to practice law.
Absolutely. Okay, our next limitation is abstention.
Abstention. This is a fascinating doctrine.
It really is, because it deals with situations where federal courts actually have jurisdiction over a case. They could hear it, but they choose not to exercise it. They abstain.
And this doctrine is deeply rooted in principles of federalism, judicial economy.
Right. Trying to avoid unnecessary federal-state conflicts, or maybe premature federal constitutional rulings, when a state court might be in a better position to resolve the matter first.
It's essentially the federal judiciary saying, look, we could decide this, but for these specific reasons, we won't right now.
One primary form of abstention, known as Pullman abstention, named after the Pullman case, applies specifically when there's an unsettled question of state law.
Okay, unsettled state law. What are the conditions for that, according to the notes?
The notes specify 3 conditions must be met. First, the case has to present both federal and state grounds for relief.
Okay, mixed questions.
Second, there must be a truly unsettled question of state law, something the state courts haven't definitively interpreted yet.
So, real ambiguity in state law.
And third, critically, resolving that state law claim could potentially avoid the need to adjudicate a more complex or sensitive federal constitutional claim.
Ah, constitutional avoidance.
Exactly. If these precise conditions are met, the federal court retains jurisdiction, but it stays or pauses the federal case.
Puts it on hold.
Right. It then directs the parties to go to state court first to resolve that unsettled state law question. It's like hitting the pause button on the federal case to let the state court clarify its own law.
Potentially making the federal constitutional question just disappear?
Exactly. And here's where it gets really interesting. It's like the federal courts are saying, hey, state courts, you handle your own house first, especially if clarifying your own law helps us avoid a big constitutional tangle.
It's a sophisticated mechanism, really, about efficiency, avoiding unnecessary constitutional rulings, and respecting the state's role, just as the outlines highlight.
And this mechanism also leads to the idea of certification of questions.
Certification. Tell us about that.
Well, the certification process enables federal courts to get a definitive answer on the meaning of state law directly from the highest court in that state.
Kind of like asking the state Supreme Court, hey, what does your law mean here?
Pretty much. This can be particularly useful in clarifying state law, where state Supreme Courts might have few other opportunities to do so, maybe because litigants prefer federal courts for other reasons.
And the notes even list examples of states that allow this certification process.
They do. Massachusetts, Michigan, Rhode Island, South Carolina are mentioned, showing it's pretty widespread.
But while certification seems like an elegant solution, the notes also warn about practical considerations.
Like what?
Well, there's the additional cost and delay involved that can be significant. Certification can take months, sometimes even years to get a final answer, stretching out the whole litigation timeline considerably.
Yeah, delay is always a factor.
And the notes specifically mention that failure to certify might even be considered reversible error by a higher court in certain situations.
When would that be?
Where novel issues of state law peculiarly call for the exercise of judgment by the state courts, and, crucially, where constitutional avoidance is implicated. The notes cite McKesson v. Doe for that.
So it underlines how seriously federal courts view the proper interpretation of state law by state courts, especially when it can prevent an unnecessary constitutional fight.
Definitely. Now, there's another significant category of abstention described in the notes related to pending state proceedings.
Right. This is often called Younger abstention, after Younger v. Harris.
And the general rule here is quite strict. Federal courts generally cannot enjoin, meaning stop pending state court proceedings.
Cannot stop them. And this applies broadly.
Very broadly, to both state criminal proceedings and civil enforcement actions initiated by the state itself.
What's the underlying idea?
It's about preventing federal interference with ongoing state judicial processes, respecting the dignity and autonomy of state courts as concurrent forms for justice. It's a powerful statement of federalism, really, comedy between court systems.
And the notes give clear examples to illustrate this.
Yeah, they do. For instance, if a state adopts a law banning certain books and someone gets prosecuted in state court under that law, they cannot just run to federal court and ask for an injunction to stop the state proceeding, claiming, say, First Amendment rights.
The federal court has to abstain.
It must abstain, allowing the state court to proceed.
Yeah.
The federal claims would typically need to be raised as defenses within the state court system first.
Okay. And another example.
If a state initiates civil proceedings, maybe to terminate parental custody, which is a civil enforcement action by the state,
Right.
the parents cannot get a federal injunction against those state proceedings. The federal court must abstain there, too.
So this doctrine ensures mutual respect between the federal and state judicial systems, prevents federal courts from becoming an immediate escape hatch from ongoing state legal battles.
Exactly. You generally have to fight it out in state court first.
Okay, and finally we arrive at the last major limitation. political questions.
The political question doctrine.
The notes define this doctrine as a limitation on justiciability that serves to preserve that crucial separation of powers within the federal government.
Essentially, federal courts will not decide matters that the Constitution has explicitly committed to the executive or legislative branches for resolution.
Or issues that simply lack judicially manageable standards for a court to apply. Things courts just aren't equipped to decide.
Right. It's the judiciary acknowledging its own institutional limits and basically saying, look, this isn't really a legal question for us to answer. It's a political one for another branch to handle.
And the landmark case Baker v. Carr provides a foundational list of factors courts consider when identifying whether a case truly involves one of these non-justiciable political questions.
Right. This is where the courts truly acknowledge that some issues, just by their nature, are simply not within their purview, even if they might touch on constitutional principles.
And the notes provide several clear examples of what are typically considered political questions.
Like challenges to the president's conduct of foreign policy, that's a prime area. For instance, a presidential decision to rescind a treaty.
The courts view those as matters constitutionally committed to the executive branch.
Exactly. Involving sensitive international relations, executive discretion, things courts are generally ill-equipped to second-guess.
What else?
Another classic example is challenges to whether the president is waging war without a congressional declaration of war. Think about the numerous lawsuits filed during the Vietnam War era.
Those are dismissed.
Invariably dismissed as non-justiciable political questions. The courts deferred to the political branch's foreign policy and war powers.
Additionally, the notes confirm that challenges to the impeachment and removal process itself are unequivocally non-justiciable political questions.
Yes. Nixon v. United States from 1993. That involved a federal judge challenging his Senate impeachment trial procedures.
And the Supreme Court unanimously said,
They effectively said the Constitution gives the power to manage impeachment solely to the legislative branch. The Senate is the ultimate arbiter of its own procedures in that context, not the courts.
Wow. And more recently, in 2019, the notes highlight that challenges to partisan gerrymandering are also non-justiciable political questions in federal court.
Right. That was Rucho v. Common Cause. Partisan gerrymandering is where a political party draws election districts specifically to maximize its own seats and disadvantage the other party.
And the court said federal courts can't touch that.
Essentially, yes. The court determined there were no judicially manageable standards for federal courts to apply to such intensely politically charged disputes. It left potential remedies to state courts or the legislative process.
So this raises an important question about judicial restraint, doesn't it?
Absolutely. The political question doctrine, as illuminated in Angela's notes, powerfully demonstrates the Supreme Court's acknowledgement of the limits of its own role, ensuring it doesn't overstep into areas constitutionally assigned to other branches. It's a key mechanism for preserving that delicate balance of power.
By comparison, a non-political question would be one that does have judicially manageable standards and is not solely committed by the Constitution to another branch.
Right. The crucial distinction hinges on the nature of the issue itself and the court's institutional ability to resolve it using established legal principles rather than just delving into policy debates or purely political judgments.
Keeping the courts focused on legal interpretation, not political arbitration.
Precisely.
So what does this all mean for you, the aspiring lawyer, the well-informed citizen? It means that some government actions, even if you vehemently disagree with them, simply aren't for the courts to decide.
It's all about who gets to decide what under our constitutional framework. And sometimes the courts, out of respect for the separation of powers and their own institutional limits, they have to step back and let the other branches do their job.
And Angela's law school notes lay out those lines pretty clearly, meticulously distinguishing between what constitutes a truly justiciable legal dispute and what is fundamentally a non-justiciable political question.
Understanding those distinctions is critical for predicting how a court will rule, or indeed whether it will even agree to rule at all.
And there you have it. Wow. From the intricate dance of original versus appellate jurisdiction,
to the crucial guardrails of justiciability, ripeness, mootness, standing,
sovereign immunity, abstention, and political questions.
We've navigated the complex, often counterintuitive landscape of Article III courts and the boundaries of federal judicial power.
Understanding these doctrines is just absolutely fundamental to grasping the true scope and limits of federal judicial power in the United States.
Yeah, it's about knowing not just what the courts can do, but what they must do, and perhaps most crucially, what they cannot do. These are the rules governing how the judiciary engages with the world.
We've covered a really substantial amount of ground today on Article 3 and judicial power. And remember, as you're studying this material, the importance of solid, verifiable information evidence, you might call it in a legal context, it just cannot be overstated.
Especially when you're trying to build a strong legal argument or just comprehend these complex legal principles, you need those clear facts, those precise details from reliable sources like these notes to back up every claim and understand every nuance.
On that note, we have to give a huge thank you to Angela for sharing her excellent constitutional law notes, the AI slip-up. Her con law notes form the basis for today's discussion.
They really did. Her insights are truly invaluable.
Okay, just a few quick reminders for our listeners before we wrap up. First, Angela is a student, just like many of you, and she hasn't passed a state bar yet.
Right. Second, neither Angela nor this podcast is giving legal advice. None of this information should be construed as legal advice. And, AI isn't a substitute for actually studying the law yourself. We're here to help you navigate the material, not provide legal counsel.
Third, speaking as AI bots, well, sometimes we make mistakes. Like that TorchCon law slip just now. Angela does try her best to fix any errors that might pop up in our programming or interpretation, so rest assured there's always a human touch in the background correcting our digital hiccups.
We try our best.
And finally, if you happen to be listening to this while driving, please remember your safety on the road is the absolute most important thing.
Absolutely. If learning about constitutional law doctrines like abstention or sovereign immunity is going to distract you from driving safely, please consider hitting pause and listening at another time.
Yeah, we definitely don't want you to cause a tort while listening to con law. That would be ironic. And bad.
Very bad. Okay, if you need to get in touch with Angela, you can reach her at podcast@studyforthebarinyourcar.com.
And for those legal writing or law clerk services, her email is hello@legalwriterandlawclerk.com.
Right, as tradition dictates, before we sign off completely, we need a cheesy lawyer joke.
Oh boy, okay, lay it on us.
Why did the lawyer break up with the paralegal?
I don't know why.
Because they had too many briefs.
Sighs dramatically.
No.
Oh, that's pretty bad.
Told you it was cheesy.
This is Claude and Ma, your AI bots, signing off. See you on the next podcast.
Goodbye, and thank you.